Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gregg, and I'm a financial mediator and business valuation expert in St. Louis, Missouri. So today I'm speaking with Kelly Lise Murray. She is a lawyer, professor, legal scholar, serial entrepreneur, and you can find her on vettingthehouse.com. She is currently our resident guru on all things law, legal cases, appeal cases, which I think are not discussed as much. And she always kind of curates these really juicy cases with a lot of valuation issues that we can discuss what they did right, what they did wrong. Welcome, Kelly. How are you?
Hi, Melissa. I'm doing well, and I'm especially excited about this little case because there's a lot to talk about.
I know you have a knack for finding these cases, and this is the Bailey v. Bailey case. And this is almost like when the divorce court gets it wrong. So like as we were even talking about this case, I was like, wait, what are they? They're talking about these factors, and are these valuation issue? Like it covers the gamut. But I think before we go off on a tangent because we get a little too excited about, these issues. I think you have to give us some reference point, some kind of background on this case, and then we can start going through. What did you say? There was like 7 issues that are all valuation related. So it's a good one. It's a juicy one. So what's happening in Bailey v. Bailey?
Well, first, Bailey is recent. Bailey decision came down in March of 2026. And if you just look at the business valuation piece of the appeal, it looks like it's not monetarily worth the cost of the appeal, but that's only half of the case. And that's how my work goes. If I'm looking for one particular issue, I don't use the rest of the case. We're not using the rest of the case. We're focused on the business issues. And the errors were all done by the court. Now, to be fair to the court, it looks like the court relied on the wife's submissions. So by extension, the wife's submissions that the court adopted to value this small, closely held business, which was a one-man LLC operation, that's the source of the error. But we have basically one paragraph that generated over 7 errors on appeal, any one of which would have reversed this.
Yeah. And kind of walk us through what you think is maybe the biggest issue, because in this situation, we have some case precedent, and you and I were already kind of talking about this, which is a big deal in divorce. Like if you're going to operate and be a financial expert, you kind of need to know, and again, a financial expert could operate in any county, in any state, right? But one of the things in divorce is it's all very state specific. So there's nuanced cases in each state that you kind of have to be aware of, just because they still bleed into these cases. And that was the situation in this case, is that there was some case precedent set. But maybe we should just go into some of the issues or how you want to kind of tee us off for this.
So here's what's going on in North Carolina. This is a North Carolina intermediate appellate decision, and a case that sets the standard is probably in existence in all other states. This particular Bailey decision would not be applicable. No one in a different state should cite this. But what you need to do is look for the standard for your state, whether you're the lawyer applying the business valuation or the business valuator, because in North Carolina, the standard is from 1985. It's the Poore case, Poore. That's a North Carolina Supreme Court case, and it set a 4-factor standard. And you and I were discussing, if you just read those 4 factors as a business valuator, it isn't a business valuation. It doesn't look anything like how you would operate. But what the lawyers need from the business valuator is the correct methodology and actual methodology, relying on evidence, not ignoring negative evidence, and then the lawyer fits it into the Poore factor. So what went wrong in Bailey is one paragraph, and I want to read the actual trial court's valuation paragraph of the business. And I want everyone to think, well, what's wrong with it before we jump into what the appellate court held was wrong with it. So here's what the trial court wrote. It's all based on the wife's lawyer's submissions. The business is marital property, and it had a date of separation value of $32,000. This is from Wife's Exhibit 27, and utilizing the amounts listed in the tax returns for income profit over a 2-year span prior to the date of separation, and also considering the bank statements found in Wife's Exhibit 34. That's it. That's the paragraph that created 7 errors. So what are the errors? The first place to look, and the first place the appellate court goes, is the Poor decision. This is the Bailey 2026 appellate decision relying on poor and the poor factors from 1985. And the 4 poor factors are: you have to look at fixed assets. You have to look at other assets, including work in progress. You have to look at goodwill, and you have to look at liability. Now, I just read that quickly. Listeners, you don't have the benefit of actually studying that paragraph, but that paragraph is missing most of what poor says must exist. And there are just a number of other things wrong with it. But for example, the appellate court points out there's no determination of goodwill. There's no evaluation of work in progress. And those would be enough to reverse this, just that. So that's just the beginning of what was wrong with this one paragraph. But for a business valuation at $32,000, factually, the business started in the end of 2019 and had just under $6,000 in revenue. In 2020, it had $68,000 in revenue, and the trial court averaged those two. Now, Melissa, what's wrong with that mathematical picture pretty much anywhere, not just North Carolina?
Well, and I think that this is a big deal because for the most part, judges will not do a straight average is the kiss of death. So you'll usually see them like whatever the average is, they'll go a little bit higher, a little bit lower, depending upon the expert that they sort of prefer. But that, in my mind, prevents them from having like an appealable issue. So the straight average is usually like a big no-no in the courts, right?
And that's absolutely what the appellate court held. So the appellate court expressly held that this trial court's judgment in this divorce was missing a business valuation method. In North Carolina and probably all other states, if the trial court is valuing a business, there must be a business valuation method, and there's none. The court couldn't find one, and then specifically pointed out the mathematical imprecision of averaging. Averaging is not a business valuation method. And so that's one of the more, that alone would have reversed this. But wait, there's more. There's more that went wrong.
Yeah.
But something else that the appellate court looked at was the evidence the trial court relied on. The trial court relied on the Wife's Exhibit 27 for the tax returns and the Wife's Exhibit 34 for the bank statement. So the wife is putting the evidence in the record. We've talked about this before. You need the business evidence in the record. If the other side isn't doing it, you need to do it. So the wife gets those exhibits into evidence, and they're visible on appeal. Well, here's the problem. The trial court, at the wife's suggestion, the trial court relied on the bank statements. The bank statement showed at the time of separation declining income, declining revenue, but ignored that. You can't cherry pick a piece of financial evidence. I'll rely on the positive and completely ignore the more recent negative evidence that this business was changing, because at the time of separation, the husband got a W-2 job. He was no longer spending time on this LLC, this one-man LLC consulting business. He was spending time as a W-2 employee somewhere else, which it also explained factually why the bank statement showed declining revenue.
Mm-hmm. Well, and I think that, when I first was taking a look at the summary, I was like, 4-factor framework. Like what valuation theory is this? And it's interesting because that's what you're saying is one of the issues. Like they haven't specified how they valued it, because what they did was kind of take these average of earnings, like a straight average of 2 years of earnings, like cash flow, and just said that was the value, as opposed to like the 4-factor framework is kind of loosely like that. I don't know if they said these words, but it's kind of loosely this excess earnings method in business valuation. Like that's how I can kind of look at it, because they, in the analysis, it talked about you have to consider the 4 factors are considering fixed assets, which is like, your tangible, your hard assets, your other assets, which could be like work in progress, goodwill. So that's where the goodwill is usually from an income approach, and so that's where I think they were going with some of the cash flow, and then the liabilities. So that's where they're kind of pulling together this income statement and the balance sheet and these methods, but they're not being very specific. It's almost like they're defaulting to the case law as opposed to what was the standard of value or the valuation method from the business perspective, right? They were just like, in my mind, they were just throwing numbers out there is kind of what it looks like from a valuation standpoint.
And then that's what the trial court did with it. And as a result, it gets reversed on appeal. If there was 2 years, and something else the appellate court pointed out, the first year was a partial year with just under $6,000 in revenue. The second year was the higher year at $68,000. And when you average it down to $32,000, you're comparing a partial startup year with 1 full year. And that's something else the appellate court held was not reliable. That's not a proper valuation method, because you're comparing incomparable years. You can't equally weight a partial startup year of the one-man LLC with 1 full year of revenue that then shows declining revenue because he's no longer spending his time in this business.
Yeah, and this is a hard issue to deal with because, again, 1 year you have about $6,000 of earnings. The next year you have $60,000 of earnings. If anybody's looking at that, and this is where business valuation gets a little murky, right? Because you would say, okay, what we're trying to estimate is what is the next year's income, right? And so, yes, we could look at the history and we could average it, but is the indicators going up? Are the indicators going down? And in some capacity, you also said, which was probably kind of important, he had stopped doing some of this business. Like he had a job, but a lot of times the dates of valuation become important, because, okay, is that job, because we can't consider anything beyond the date of valuation. So like if that after the date of valuation, it burns down and doesn't exist, we're still valuing it as of the date of valuation. Like it did exist at that time. We have no foresight of what could have happened. But, so to me that it would seem important if the guy had another job, right? Is a business viable kind of situation. But
here's another error. The trial court didn't resolve the dispute date of separation. This business was supposed to be valued as of the date of separation, and they have 2 disputed dates. One wanted an October date, the other wanted a November date, and November is when the husband takes the new job with the W-2. So that you can just see, it's amazing how one little paragraph resulted in all these reversible errors, any one of which, and you just explained it before I even got to the law, if you don't have a date of separation or the valuation date, whichever your state's practice is, and it may be different by type of asset. But here for this business, the valuation date was supposed to be the date of separation, and the trial court did not specify it. It danced around it. That's a separate reason to reverse, just that alone. And the costs of going to trial in the first place, then the appellate cost to then get remanded, the net just isn't there.
Yeah.
Which Melissa and I have been discussing among all of the cases we've looked at. Put the effort into the trial level evidence for the business. If the business matters to you as a significant asset, put your effort into your evidence, into your trial brief, into what you're giving the trial court on the record. Show the trial court that the other side is leading it to a path of reversal. Judges don't want to be reversed. Trial judges don't want to be reversed. That's another strategy where you would show the court, not only ours works, ours fits so when it was North Carolina, our business valuation, our evidence, our analysis fits the poor framework. We've answered all four things. Our business valuator contributed, and then we, the lawyers, did the rest. Here it is, all affirmable on appeal, Judge. And look what the other side's leading you astray, because here's how the other side is violating the poor factors. That's another lesson of this recent Bailey decision. Show the other side is leading the court down the path of reversal. This is embarrassing to get one little paragraph with over 7 errors. No trial court judge wants that. That's bad.
But like maybe I'm missing something, but like they didn't really have an expert.
No.
Right? Like they were just presenting this evidence, which is probably why, it was a little bit, because it was a little bit unclear, right? Because if they had had an expert, they would have presented it, but they were trying to use documents that were supplied by the other spouse and come to, some rational way, which a lot of people do. Like if it's just factual, like if there's a cap account or if there's a balance sheet that is just like, here's what the value is. But the problem is if you're relying upon one of the parties to testify to that, are they an expert? Do they have the capabilities? And is it going to, like this, it's a $40,000 valuation that's now going through God only knows how much time and effort in appeal, when it literally looks like it's been like throwing a couple numbers. Because what they would have done, even if it was a declining business, is they would have just looked at what the assets were, like what is in your bank, which is kind of where I think they were trying to go, like, oh, he had income, but like what is still left in the bank, right? What are your assets? What are your liabilities? Is there anything that you could sell? Is there a customer list? Is all the goodwill personal? That becomes, but there was no discussion of any of that, right?
Right. And that's where talking about what goes wrong in a litigated case on appeal is helpful to all of the professionals involved. If your divorce case and you're the lawyer does not have the budget for a business valuation because the business only made $68,000 one year and under $6,000 the other year, that makes sense. You've got to budget your due diligence. Even so, you, the lawyer, still need to meet the 4 poor factors. And what's interesting in the Bailey appellate decision, it tees up 2 additional cases as precedent showing using the poor factors with similar facts, a similar result happened, meaning the trial court's business valuation was reversed. And that's classic. And that's why, as lawyers, we look at precedent. One case was from 1986, so a year after Poor. This is the patent case. And just listen to this. This gets reversed. This was the trial court's valuation of a closely held corporation, the husband's interest in a closely held corporation, at least $85,000, close quote. Here's what's wrong with that. If you remove at least, that probably gets affirmed on appeal, but at least means the trial court didn't value the business. It's at least this, and I'm going to not do the rest. That violates the poor factors. That is not a court valuing any asset, let alone a business asset. That's why that was reversed. And also that number is based on the husband's own estimate. So there were a number of problems. And what the North Carolina Supreme Court pointed out in this 1976 application of Poor in the patent case was simply that the trial court they call it an enumeration of the factors, meaning here are the factors and here's my number, with no analysis, no connection, no show your math. This is a failure to show your math problem. A more recent case that the Bailey Appellate Court cited was the Stowe decision from 2020. And this was the failure to include goodwill. So the trial court found that the business had certain goodwill, but didn't specify in its valuation of the goodwill. It didn't specifically explain how it valued the goodwill. You can't just say there's goodwill and then not value it. Sometimes that's an evidence problem. Sometimes neither party presents the evidence. And that's when a trial court will order things like an appraisal for any asset if there's zero evidence in the record. Here in the Bailey case itself, we had the documents. We had the actual evidence anyone could rely on. We just didn't have both sides presenting to the court how to satisfy Poor. Whoever had written Poor correctly, is what the trial court should have adopted to avoid being reversed on appeal. This is a huge motivation for trial courts. Do not underestimate. They do not want to be reversed on appeal. If you have the better argument, if you can show that the other side would have the trial court violate POR, then put that into your argument. That can be in your trial brief, and that can be argued in the trial itself. You can't, relying on that violates the standard. And here in North Carolina, that standard is POR from 1985. But then we were talking about, Melissa, about how sometimes you're stuck with a case that doesn't value businesses correctly, but you just have to figure out how to deal with it until someone finally appeals to get it reversed.
Well, and I think that this is in divorce, the professional practice is the most difficult one to value because it's reliant upon the business owner. How reliant is the question, right? But we have a lot of people that are like importer exporters. They're, sales people for distribution places. Like they are really going out and earning this money. And so a professional practice, I think that one of the issues in this case was that the trial court that you just said never addressed goodwill at all.
Right.
So even though this was a service LLC that was driven by this owner's labor, this was a central issue to the appellate court that there was no sound method used. Now, the interesting thing is that there's a whole bunch of complications that they don't talk about. And one is that when you're valuing a professional practice, you have to look at, is this income or is this an actual business asset, right? If I'm just have a glorified, like if I have an LLC that I'm just making glorified salary, right? And there's no additional amount available after I pay myself a reasonable salary. Is there really a business? Like, is this just an income producer? And that's where we get into like the double dip. So you can only use the income for the business value or for the payment of a spousal support. Like there's a lot of things, but couples, when they go through the divorce process, they're like, well, but he's making $300,000, selling widgets for this company. There's got to be something with it. I encourage you to think, and I'm not saying that these things have no value, but I'm encouraging you to think, what are you selling, right? So if this person is an importer exporter, and a lot of times what happens is company pays somebody to go in and they get like big shipments through customs, right? So there's a lot of cash coming in and there's a lot because they're having to transfer it for, getting it through customs. Yeah, there's a lot of dirty work that happens in there too, bribes and stuff like that. Let's not talk about that. But at the end of the day, is that person just really making a wage? And are they making, they're making 300,000. Like that's a pretty good wage. But what portion of that would transfer? Like if Kelly came in and she bought that service business, right? Can I really go in? Like, do you know how to get things through customs? No, I don't either, right? So is that a saleable entity? Because I think we get distracted in divorce of like, I'm going to go after everything. And if a lawyer says, yes, let's go after everything, but there's no plausible reason, like the courts and the judges will still respond to logic and make sense. And in these situations, because they didn't address it, like maybe there were no liabilities, maybe there wasn't any goodwill, but it wasn't addressed. It wasn't formally acknowledged. It failed in the appellate courts. And I think that that's important. Like we get in the weeds of these valuations, and if we're not describing it adequately, it's going to fail. In this situation, they didn't have an expert. They were piecing it together, but it still failed. And it cost probably more than it was worth at the end of the day.
Absolutely. Now, the other half of the case related to a house and maybe the math nets out better on that side. But from the business side, absolutely. This is the type of case that wouldn't get appealed. And just think about that for a moment. This trial court decision is wrong. It's improper, and it fails to correctly apply the POR factors. But if no one appeals, that's what happened in this divorce. After 30 days, if no one files a notice of appeal, it's done. That's it. That's the decision. Which brings me to the checklist that you just described. Knowing what the standard is in your state is what you have to do, should be delivering to the trial court if you're not settling at mediation. So if you're going to trial on assets like a business, if you have a business valuation, you still have to write it up as, here's how that fits the poor factors. Here's how we're delivering the valuation based on poor, and this is the number. And what the husband's side could have done, and we don't know that they didn't, but it's just not in the appellate record. But what they could have done is shown there is no sale of, here's the goodwill. It's personal to him. This whole business was him. That's what the appellate court actually points out in its decision in the Bailey case. This was a solo LLC sale, consultant business. Of course, the goodwill is personal to him. If he's not doing the business, there's nothing else.
Right.
But using this standard as the checklist, this is what you would bring if you're going to trial on these assets, on valuing these assets and dividing these assets. Then you need to know what the trial court has to produce to not get reversed on appeal. They don't know you're not appealing them, and they do not want to be reversed on appeal. So that's the strategy. We have a methodology. Pick one. There needs to, so one of the takeaways of Bailey, there needs to be at least one recognized methodology. You've got to have something that's actually a business valuation methodology. There was zero here. There was actual evidence, but even the evidence, the reliance on it, when the evidence shows good and bad and you ignore the bad, that was reversed. And that's what the husband's side, that's where they could operate, is pointing out the negative, here, yes, here's the bank statement. Yes, here's the tax returns, but here's what it's showing now that he has a W-2 employment and is no longer putting full effort into this LLC. There's nothing to sell here. There's nothing to transfer to anyone. And so that was his income. Now he has a W-2 income.
Well, and I think it's interesting because I like that there's not an expert error. I like that, what I think happened is that these lawyers looked at this and said, you know what, this isn't that big of a deal, right? 20,000, 30,000, 50,000, whatever it is, we're going to just put some number, like we're going to present some information. It's going to be very simple. And in the simplicity, they failed to just fully kind of explain it away or whatever. And it ended up probably costing this couple $100,000 to inappropriately value an asset that was sort of thrown on there. Like if an expert had come into this situation, that would have been a mediated issue. Like that, we would have just agreed, hey, there's some cash in the bank. Let's just say it's worth 30,000, boop, 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 stipulate to it and be done. But because there was no experts and you have like people just going in either, the actual, and because again, it could have been the lawyers. It could have been the people. The people could have said, oh, let's just throw it in there. I'll testify to it. I got this. No big deal. This is super simple. That's what fascinates me is in the simplicity of it. You didn't check a couple boxes and you just caused this to be a whole bunch of issues that were unnecessary.
Right. The net isn't there. The net absolutely isn't there to even appeal it if you don't have the other issues that were appealed. So this was not the highest net worth divorce. This was not the most complicated legal issues. And it's mostly numbers. And they did stipulate to things. The only things they stipulated to about the business was that it was marital. You know why the husband stipulated? Because he was confident it didn't have saleable value. That's why he stipulated to it. And that's a good decision. Don't fight on things that they don't net you more and that you probably aren't going to win on anyway. So it was easier to just say stipulate it was a business decision. And the disputed date of separation, probably because one was before he had the W-2 job and the other date was after. And that's why they were litigating that. And the trial court never put in, this is the date of separation. I'm holding, this is the date of separation. That's missing entirely. And so any lawyer with a business valuator or without, it's still your responsibility to know in your state what the mandatory factors are and make sure your presentation fits them, and your rebuttal of the other side shows how they're violating. In this instance, it was the poor precedent, the poor factors from 1985. That's a strategy you can do at the trial level. Hopefully it will convince the trial court it should follow you and not them. And then that goes up on appeal, and then you win the appeal because you showed you followed poor and they didn't.
Mm-hmm. And again, I think professional practices are where you're going to see a lot of case law about it, because people have come in to try to say that there's a huge amount of value. So again, he had like $59,000 of net income. I think it showed that maybe there was slightly higher of revenue, which means there was only like a couple $1,000s worth of expenses. All the rest of it flowed to the bottom line. And again, if I had been on their side, I would say, yeah, he didn't make enough money to pay himself a salary, so he went and got a job. And all of this would have still just been an asset that was still sitting there, if anything. Now, I think that another piece of this, though, having to do with like the valuation methodology is, again, going into the court. And I was presenting with a panel of judges for quite a while over the past couple of years. And it was always fascinating to me because I would tell them the things that I would see that would be happening in the divorce court system. And the judges would be like, well, that shouldn't be happening. And I was like, yeah, no, I'm not like making this up. Like,
right.
Because they would be like, well, the judges should pick one of the experts, right? If one expert says this amount and another expert says this amount, they should never be going in the middle. And I was like, yeah, but okay, that happened, so it's very much a perception thing. And these were judges that were in appeals courts, right? They were in bigger district courts. So they're like, oh, that should never be happening. Well, what's happening at the divorce court level is a whole bunch of craziness. Like, you could learn a tremendous amount at the crazy level of divorce, but it also is understanding the case law precedent, even if you don't like it, right? Like, there's a case in Missouri that we hate, right? But it was created to gain clarity in some of these areas of professional practices. Those are very hard to get rid of because we don't have people going all the way to court. If we have 90% of cases settling, we don't have them pursuing it in appeals either, right? Like for this particular case, if it wasn't appealed, it would have just stood even in its error,
right,
and been perfectly fine. But the minute a judge averages, just straight averages something, that is part of the problem. So you'll usually see, and that's what I tell clients, I was like, we'll see the indication of what, if the judge bought our position or the other side's position, because they'll go slightly towards our favor. Very rarely do I see them just choose one expert. Now, in this case, I think that the court actually had to just use the information and maybe the testimony, and then came up with a number and got it wrong, which is what the appeal court said, is like, you did it wrong, trial judge, which again, I think that's the biggest issue, is that the court doesn't want to be found incorrect. So they want those experts in, or they want to pick an expert and rely upon it.
But that's the opportunity to show the court, here's our version. And of course, we're fabulous. And this is what, judge, this is what you should accept. And here's what's wrong with the other side, not just on the math, but legally. What they're presenting you, judge, violates the poor factors. And then educate the court on poor. The judge, depending on your system, if you're in a large city family court, well, that judge only hears divorces. But if you're in putting the circuit in circuit court, meaning the judges travel to several counties to hear all kinds of different cases, the types of case law, the types of legal practice, most lawyers wouldn't practice all of it. These judges have to judge all of it. It's a lot. Our goal here, and one of the takeaways from the Bailey case, is make it easier for the trial court and give understand the precedent, use it as a checklist, show how you followed it, and show how the other side violated it. Meaning, if you pick them, judge, that's the implication, you're going to get reversed on appeal. That's another reason in your favor. So that's all the persuasion. And that's why mediation is 90% the resolution center for these types of issues. But that's also part of the calculus. What would happen if we went to trial? What is this case? So in Missouri, there's a case no one likes. All right, well, that's going to affect decision-making in mediation if that case in Missouri impacts your Missouri business valuation. You would take that into account when settling.
Well, and I think that if you don't understand the case law, it's kind of showcasing that you are blissfully unaware. Either you don't operate in that area very often, or something as such. But this is where I think that there's a gap, because I think that lawyers will try to use their clients to introduce evidence, to talk about things. And at all times, like, they're more fact witnesses. Like, they can come in and talk about the facts. Like, yes, the fact was that there was income at this level of 6,000. And then the fact was the next year it was at 60,000. And those could be entered in facts. The moment that one of those parties tries to make an opinion about it, which would have been, okay, how do we average it? Or I think that this going forward, at that point, they're missing that testimony, right? Because the fact witness can only take it and introduce the facts. They can't actually supply an opinion, and the other side can't actually supply a rebuttal, right? They don't have the expert to discuss that in some capacity. So they're probably relying upon the couple to testify, like the husband who was working probably testified, well, I don't work there anymore. I'm not making any income. I have a job. And they thought that that would be good enough. Right. In some of this situation. So it's really
the trial court has to value assets in divorce. And when there's zero evidence in the record and parties didn't settle on that asset and the judge has to value it and there's zero evidence, that's when a court will order an appraisal of any type of asset. There has to be some evidence. The court cannot make it up out of thin air. Even this monetary evidence, so the bank statements and the tax returns, that is enough for the court. With the lawyers guiding the court can value the business. It has to. And with some guidance, yes, a business valuator would be better, but we understand the numbers weren't there for this case. This was a very, it wasn't even a 2-year business before they separated. He now has a W-2 job. He's not pursuing it. So the economics of that make complete sense, but it didn't save them from failing to follow the poor factors. And that's where the advocacy comes in the trial court. If you're going to trial on your business valuation or on your business and you need the court to value it, give the court what it needs so that it can, and show the court, all right, here's what poor requires. All of our evidence, all the testimony meets it. And this is the number you should come up with. And also then in the trial brief, the lawyers can point out what's wrong with the other side legally, just like it's like a pre-appeal in that sense. Here's, judge, if you follow the other side, here's what's wrong with that. It violates poor. It's like Patton and Stowe in North Carolina. Both of those got reversed and you'll get reversed too. That's the implication. So that's the strategy, combining these two things. Do you have the underlying evidence? Do you have the factual testimony from the spouses? Now, spouses who own property, anyone who owns property in many states, can give a lay opinion of price for that property. Doesn't mean the court's going to give it a lot of weight, but they actually can do that. I've seen that a lot with houses, and you and I have talked about a few cases where it was the business, but sometimes the court's like, that spouse is totally out to lunch. No, I'm not relying on it. And then, I'm going to rely on it because there was no business expert on the other side. And this spouse actually presented actual valuation methods. You've got to tie it to something or the court should reject it. Averaging, the court should not accept averaging. The strategy here we're talking about is, yes, ideally everyone has a business valuation. If the numbers aren't there, you still have to look at settling, or if you go to trial on a business valuation, make sure you know what your standard is. In North Carolina, it's the poor case. Every state has a version of that, and it may not read the same way, but that's your checklist to make sure your evidence and your testimony, and then your lawyer applying all of that, showing that it meets what you're presenting, meets poor and is not the two cases that got reversed, Patton and Stowe. So that's the strategy at the trial level. And that's the same thing that happened on appeal. On appeal, one side said, this would be the wife's lawyers, we did follow Poor, we are not Patton, and we are not Stowe. And they lost on all of that because they were like Patton and they were like Stowe. The trial courts in both of those precedential cases simply wrote out, here are the Poor factors, and didn't show the work, didn't do the math, didn't actually show that the analysis was done. So that's the job of the lawyer at the trial level, or if you're self-represented, that's your job. And that's why not to be self-represented, litigating a business, just, how difficult that would be, which corroborates why 90% of these cases are going to settle in mediation.
Yeah. And I think that, again, a good plug for mediation, because in this situation, if they had a financial mediator come in or a financial expert, I think that that person would have said, you know what, we should just try to agree to what the value should be. We should, try to discuss this. This is not an issue that's big enough to go to court for, much less, have an appeal for. But I don't think that people are understanding, like, you should vet your case of like, what is best case, worst case kind of situation in here, and try to settle, because this case should have never gone to trial.
Certainly not on this business. Absolutely not on this business. They did stipulate to things on the business. They only stipulated that it was marital. They didn't stipulate to anything else. And just what you described absolutely is what should have happened in a case like this, where the business is winding down because the spouse, the solo LLC consultant person, now has a W-2 job that he has to put his full effort towards. So we know where it's going, and a financial mediator could show both sides, you can't average it. That's wrong. And any court that averages it, that gets reversed on appeal, showing them the general costs of appeal. Those are all tools to show people your best net is right now. Because this ultimately, it should be about net. What are you netting? Not what are you spending to net even less? You go to trial, then you appeal on something this small. Now, this appeal had a whole nother side, but really, they spent effort on the briefing on this issue, and the net is just not there.
Yeah, and I mean, to me, after seeing enough of these cases, I think that there was obviously a lot of toxicity, because you don't take these types of small issues to court if you guys are rational and can discuss things. So obviously, somebody had a position, or there was other manipulation in the money, because they were sticking so hard to a position. Like, we had this recently in a case where, there was an expert that came in, and I mean, literally it was a business that couldn't have had any value, like it was like so enmeshed in that person. And yet the expert was like, oh yeah, we'll charge you $10,000 to value it. We'll put forth a value. And, my client was like, what's it going to come back as? Because I think it was like a joint expert or something. And I was like, it's going to come back at nothing. Like, this is like, the fact that somebody's going to charge you to value this is insane. It came back to basically nothing, almost like this was like, oh, a little bit of money in the bank and a little bit of this. Now the value is $8,000. And I was like, that's the travesty that's happening, is that we are assuming that the court can handle these complex or even simple types of situations, as opposed to you have more control in mediation, and even to try to get something settled, so that maybe everybody would be like, what, should we really argue about $30,000, or just agree to it in some capacity? So to me, that is a red flag for this case, for sure.
Well, and if the business value, that's not even dividing it. If it's $30,000, what are you spending to go to trial, and what then did you spend on appeal?
Mm-hmm.
The net's not there. Really, this net value, the net calculation, what am I going to net on this asset versus what am I spending to achieve that net? And how does it get reduced because I'm overspending on an asset that we could talk about? And that's really the biggest takeaway on these types of cases, the financial mediation aspect, where the mediator
Mhm.
has the experience, because that's what I've personally seen. Anyone can become a mediator, and unless you're court appointed, there's no licensing, there's no regulation, and there are some organizations, but it's more of a trade group as opposed to a licensing situation. So you can choose almost anyone to be your mediator. Well, look at your assets. What do we need? What do we need the mediator to have knowledge of? And that financial mediator with experience in business valuation, if a business is at issue and you haven't separately paid for a business valuator, look at what you're getting. You're getting someone who has the framework to help look at your evidence, look at their evidence at the mediation table, and get you to a better resolution that nets you more. I mean, to me, it's just
Mhm.
what's your net? What's your goal and how you're going to net that, and overspending to net less and just be in the years of litigation, because an appeal is 2 years minimum. It takes a
Yeah.
long time to get through an appeal. And so you're talking
Well, and this
tens of
is
thousands of
where,
dollars in litigation.
yeah, we have like we have a lot of cases with really brilliant people, right? So they come in and they're like, okay, we should look at this value of this professional practice, or doctor, dental practice, whatever it is, law office, all of these that are kind of contingent upon the person. Now, I have a lot of finance people that come in and be like, you know what, we should be looking at this value of like how we sell it, how we sell it on the open market. This is what other companies. So a lot of times when people are coming into the court system, they're like, this logically makes sense of how we would value it. The problem is, if there is certain case law that goes a little bit outside, like I always try to tell people, like when you're doing things in the divorce court, it's almost like the Wild West. Like there could be nuances of that state that categorically go against logic of people selling businesses, right? Like this is where I get into trouble. Is like, I'll have financial professionals, they sell businesses, they're in private equity, right?
Mhm.
And they're like, this is not how businesses are valued. And I was like, I understand that. I understand that. But this case in your state is going to change everything. And they're going to be like, well, that case is stupid. Yeah, don't care. This case
It's
is
still
going
there.
to determine everything. Like in the state of Missouri that we were talking about, this Hansen case. Hansen case is going to dictate a professional practice. Period. Oh, I don't like Hansen. Yeah, nobody cares. Well, a lot of us don't like Hansen, right? But we can't get it to be not precedent unless it gets like supplant, like some other case comes in. Well, nobody wants to fight it because it's kind of ironclad. And I think that's what you have here is like you had 4 factors to deal with. You should have just dealt with them and you would have complied. But everybody wants to go in saying, well, I'm in finance, or I know how businesses are really sold. Yeah, the divorce court in your area has determined that it believes that it could do a certain thing a certain way, right? And the states are very different. Like that's what gets people, like, you have to add the layer of chaos for your divorce court system and understand, even if you know how to value businesses, well, that's not how you value businesses. I understand. This is where I think it trips regular people up, lawyers up, valuation people up. Like these are smart people, but the court will sometimes create these little barricades that you have to go over, and you hyper analyze the case and you're like, well, that goes against logic. It goes against valuation theory. Yeah, yeah. But that's the nuance of being an expert in that space, is how do you parlay, like the Hansen case, there's literally like 3 lines in the case that are hyper analyzed, right? Like every single word has been hyper analyzed for the implications to a professional practice, right? And even to the point where there's an and or. And what does it mean? And you need both those people, or is it or you just need what, like, oh my gosh. But again, that's the sort of due diligence. And I would also say you can't rely, for these very unique valuation cases, you can't always rely on the lawyer knowing the case law, even the case precedent, because if they haven't done a lot of business valuation cases, they may not be privy to a case from 1987, if they haven't fought that issue. And even that issue is not a valuation case. Like the Hansen case in St. Louis in Missouri is not a valuation case. It is so it doesn't apply to all valuations, only professional practices. And even the definition of what a professional practice is has been highly discussed. Like, what are the nuances of a professional practice? It's when you have a credential that has a governing body. So like a mediation practice
would not
necessarily qualify, right? So that's the nuances of understanding. And I've fought it in court, and it's very clear when an expert has not read it 1,000 times and analyzed it 1,000 times. It becomes very very obvious when they're testifying, or even when they're deposed, that they had no clue some of these nuances of the cases, because it's almost a open and shut type of situation. Like, you either comply or you don't. It's very obvious to people who are operating in that state. So be mindful that it will show that you might not know everything that's going on in that state. So
absolutely. And the way litigators operate is you work on what your client needs to be done. Unlike other practice areas or professional areas, you have continuing legal education opportunities. You do have to complete a certain number of hours to renew your law license. But beyond what your current practice is and continuing legal education and legal news, you're not going to be aware of things that have been outside the scope of a client case need. You're really focused on, what do my current cases need? I know what I've done in the past. What do my current clients need? And so if this type of business is new to this particular lawyer, or business valuation as a whole is new, that needs to be addressed as, we need a checklist of here's the mathematical evidence, here's the proposed testimony. Now, what's the legal checklist? So you have to have both, or you really should be settling. You should work even harder to settle at mediation. If you don't want to get to that next layer of what binds a trial court in divorce when valuing this type of business. If you don't know that, and you don't have a lawyer, or if you do have a lawyer and that hasn't been included, you should work more towards settling at mediation than going to trial, because that should be governing what the trial court can do and does, so that you don't go up on appeal and you don't get your positive ruling reversed on appeal. That's the goal at the end. You want to resolve it at the trial level, so no appeal is necessary. And if the other side appeals, you still win. That's what you want.
Well, and that's why, like, a lot of what we're doing now is coming in from big strategy at the very beginning and saying, okay, let's look at this whole case. And there's these 10 issues in the case, and here's $1 million issue, and here's $100,000 issue, right? Let's spend more of our time in fighting these bigger issues. And so in my mind, if you're not working with an expert that's coming in and kind of giving you a big picture, and probably we have done it this way because of our forensic and fraud background. Like, I'm not going to go chase a fraud case unless I can clearly see that there's going to be some result at the end. The same with pursuing divorce issues or valuation issues. Like, this was a flimsy valuation to begin with, yes. Right? The fact that anybody pursued it was because there was no financial expert that was coming in and saying, and the client could have been like, well, it's still money. It's a big deal. I get that. But if you don't have somebody that is a voice of reason coming in and looking at your big picture case and saying, okay, here are the areas we're going to fight on, here are the areas we're going to concede on, then in my mind, you're going to absolutely overspend on that. Because like this case, I would have been like, we go direct to mediation.
Yes.
There's no reason to go to trial for any of this case, which is why what I know is that you have a toxic somebody in this situation is toxic. I don't know who it is, if it's the parties or the lawyers, but somebody took this way too far for
Yes.
way too long when it could have been settled.
And stipulation. So the legal technique is request for stipulations. Stipulating saves you. You don't get to relitigate. It's done. So when you stipulate to this is marital property, you're saving litigating characterization. That's expensive. And then valuation. If you stipulate to these are the tax returns, these are the bank accounts, we stipulate to these assets and these liabilities, and this, you could even stipulate to goodwill. Any of that would mean you're closer to resolving it at mediation, but also you're reserving for trial only what you need a judge for. Don't give the judge the whole thing. You're going to spend more money and you may not get the result you want. Stipulations govern the judge too. He can't go against it. So if you've already stipulated, boom, that's it. You can stipulate to the date of separation. You can stipulate to these things that are expensive to litigate. Now here they didn't stipulate because, just as you pointed out, the date of valuation of a business can make a huge difference if the business burned down the next day. So that's one where stipulation would be harder if there is a massive change in value between date one and date two. That definitely is something people do take to trial.
Yeah, and it could have also been handled by a simple report, like a one page, because a lot of times when we're mediating a valuation, I won't put anything in writing until the parties are going to agree or stipulate to the valuation. Like it's a preliminary, it's a big picture. Like in something like this, I would have been like, hey, it's $38,000. Like, can we stipulate to this? Oh, you don't agree? What do you, 20,000? Like, what do you want it to be?
Where's the space? If there's not much space between the two, that's mediation and a financial mediation. This case needed financial mediation. Absolutely.
Yeah, for sure. But I think it was a lot of good lessons, a lot of good, again, this is not, you did not hear one single thing about that there's 3 ways to value a business, right? You heard about a 4-factor, very specific to North Carolina, which I have had the pleasure of doing cases in North Carolina, and there are a lot of interesting nuances to North Carolina that I would not say are totally good, but are a little antiquated. And but again, you have to follow that sort of position. And I think where it becomes gray is in the valuations, in the tracing of separate assets. There are usually cases that will dictate how that is done, whether the presumption is separate, whether the proof is, proving that it's separate, all of that. So, hire the right people, but also understand that lawyers are giving you legal strategy and financial experts are giving you financial strategy. And the best team is kind of pulling those two together, and that everybody is listening to those people, like discussing some of the issues, and you're making educated guesses. Because again, we've gone to trial on crazy positions before where the client really wanted to pursue it, which again could have been this issue here. But from a legal and financial perspective, our role is to give them the knowledge that this is a flimsy position, the knowledge that this is going to be an issue, that like you're spending more money going to trial than you would. But again, this is what happened. For hindsight's 2020, and I appreciate this case. Kelly, any parting remarks that you have about this case that would be good from an appellate standpoint?
Just to make sure that you know the standard to value that type of asset, because this poor case looks like it's limited to a solo LLC, the individual, and not a widget factory. It doesn't look like that. So just make sure you're aware. And that is your checklist for the documentation you need, which will turn into evidence, the testimony that you need, and then the presentation to the trial court through your trial brief, through your presentation of witnesses. So it's really it's the start and the end. It helps you set up as a checklist. What do we need to meet the poor standard in North Carolina? We're going to need all these things. Once we have all those things, we need a lawyer to make sure we have met it. We need a lawyer to show us that the other side didn't meet it. And that's what we'll do if we go to trial. But it'll be even better. Maybe we should do a financial mediation on these issues, because there isn't enough value in this now declining business to even get a business valuation. We get a financial mediator with business valuation experience. That this is a classic fact pattern where that would have been a more successful path to resolving this divorce.
I mean, do you think at all, like, I could have sued the lawyers for like taking this too far?
No. And one of the things about appellate decision, we don't always have access to even the appellate briefs, and we only see on appeal what was preserved. So we don't know what mistakes were made at the trial level, because if it was invisible at the trial level, it's invisible on appeal. We don't have that full picture. But this is choosing to litigate. At the end of the day, the client agrees to litigate. If the client doesn't want to litigate and wants to settle, there's a lot of pressure there to get that settlement. And also looking at the budget and being upfront. This is my legal fee budget. It fits what I need for financial mediation, but I don't have the budget for a business valuator, because what we're looking at is, if you average it, it's $30,000. Why are we, we can't use that average, but that's a good number to start with. Is there even enough net here for me to hire a business valuator? So do your budgeting on what your fees are going to be at the mediation versus going to trial versus a possible appeal. Is there enough net to support the escalated litigation path? For many instances, mediation, especially a financial mediation, can help you resolve a case like this, where you get the benefit of the business valuation knowledge from your financial mediator, but you didn't separately pay for a business valuation. That looks like a good compromise as a starting point. And in more cases than not, you probably will be able to settle the business side.
Well, and this is where I have encouraged other valuation experts to really go into the mediation space, because I think that like what we've done is be like, oh, okay, you're hired to do a business valuation. Okay, let me go and calculate that business valuation, as opposed to, when we're looking big picture, like let's look at the full spectrum first. And I think we need to do a better job at going in and giving very clear advice of like, okay, this isn't, the place to spend the dollars, like go over here and focus on here. But I think if we start giving them a better picture, but this is also the area where, I would say, quite frankly, lawyers don't always want me to get involved, because this would have ended a lot sooner, right? So there's a juxtaposition even in that space of lawyers trying to litigate as opposed to financial people trying to mediate. And again, you have to take that into account, the full spectrum of options, but as you choose it, and don't get married to one issue just because it has some legs to it or it has some value. It's like somebody should have come in and said that this was foundationally not sound. And I think
this is your team to start with. This is your financial future that you, the divorcing spouse, have control over. You choose your team. When you choose, you need to get this information of what are the top issues, what is my due diligence budget, which includes, do I need expert opinions on anything? What would that cost? What's the potential upside? If the cost exceeds what I would net, or it eats away at my net so that I don't net very much anymore, you're leaning more towards mediation. And there are plenty of lawyers, especially lawyer mediators, who understand the process and who value mediation. What you would avoid would be that cliche on websites, aggressive representation. That's a litigator who litigates first and isn't as interested in mediation. But you can work with lawyer mediators as your lawyer, because they understand the mediation process and have chosen that as part of their professional practice. And then actually working with a financial mediator brings you the best of both, because you've got that lawyer mediator as your lawyer. You've got your financial mediator, so that you don't necessarily you benefit from their personal professional knowledge without paying for a separate business valuation. And they can, as the mediator, show both sides. All right, you ignored goodwill. you averaged it. None of those work. And so here, let's talk about the issues that we know in our state are in this poor factor if it's a mediation in North Carolina. So that's the combination I would recommend when you're being mindful of your team selection from the start. Getting that advice of where should I invest my due diligence dollars, because there are going to be assets where you should, and then there are other assets and issues where stipulating is a much better path forward.
Yeah. And I mean, just, and I didn't think it was so possible in the past. Like I thought, okay, we're always going to have to charge like $5,000, $10,000, $15,000 to do a valuation, as opposed to now we're really doing strategy sessions. And within like 1 or 2 strategy sessions, which are only 90 minutes long, like we're looking at the big picture balance sheet, like their full marital balance sheet. We're looking at the business tax returns or the personal tax returns. And so, and again, I've been doing this for like 25 years, but even somebody who has done it for 10 years or something like that, they should be able to, within a few hours, look at your case. I don't care how we have a case right now where we have 40 plus entities. I can still go in and that takes a little bit more time.
Melissa.
that takes a lot more time. But if you have something simple, right, even a couple valuations or a couple properties or some complexities or some separate or some hidden, somebody who has seen this can come in and they can look at those tax returns and they can tell you within a few hours, do you have a big valuation issue or do you have a little valuation issue? And they should be able to tell you what would be involved with that. So, and if they can't, that's why we're doing these strategy sessions. Like we're not always entering as an expert, but we are definitely coming in and saying, hey, this could be mediated. This could be litigated. Here's the range of value. Can you settle it? And we're running these parallel tracks where you're settling it and trying to litigate it at the same time. And whoever wins, right? I'm obviously hoping to settle it faster. But if you talk to a financial expert and they can't within a couple hours give you a big picture, move on to the next one, right? Like I see too many valuations that I could at least easily look at tax returns and say, you don't have a valuation issue. Like, let's just put a little 1-page wrapper on this and call it a day. Let's do your 4 factors. Let's boop, 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 1 page. Here you go. Done kind of situation. So, I think we all have to do better and be more efficient in this process because, cases like this really shouldn't happen. We love to learn from them,
right? And we're going to learn from them. We, thank you for showing us so that we can get the word out and really help others move more towards that triage, that diagnosis process, which I highly recommend, because in other assets, business valuation and other assets, that's absolutely an early step. Where should you invest your due diligence dollars? Then where should you be prepared to go further if you can't settle, because there's a lot of value there? And where should you dial it back, because there isn't a lot of net at the end of the day? And if it, in the scheme of things, you're going to resolve it more cleanly for less expense and less stress and all of those negatives that are involved in this very difficult process.
Yeah. And it's interesting. I interviewed another person this week. His name is Kendall Peterson. And he talks about like the health assessment. He does like these health assessments of businesses. And it's almost like, and I was like, oh my God, that's fascinating. He's like, oh, you could do a health assessment for that. I was like, you're right. Like that makes sense. It's almost having somebody come in. I think you should do it with your lawyer too, but I don't see them, gauging this as easy. I think it's easier in the financial realm because we do sometimes need to pick the lane that we're going to spend the most time in, that's going to have the most impact.
I do have something I've been teaching since 2008, and this is on the house side, where I have a lot of experience in valuing the house and what goes wrong when you litigate house issues and the mortgage issues and secure debt issues. And that would be to retain a real estate lawyer for a few hours, which is not a divorce retainer. It's not thousands of dollars. If you have a significant investment in your primary residence, or there are multiple houses, or there's a characterization issue, meaning it could be, an inherited house, or there could be some, did it become marital? Did it get transmuted? Or is it truly separate? Those types of issues, you could spend a few hours with a real estate lawyer and get legal advice specific to your state before you go to mediation. And that would be similarly valuable. And I've been advocating for that for years. So there is a little bit there, and it all together, you just look at where you start, and then get the financial information, because at the end of the day, most of the fights are about the money.
Yeah. And I mean, don't ignore second opinions. Like when we're hired, we can be hired as an expert witness or a consultant. At the point that I'm hired as a consultant, which is a lot of the work that I'm doing right now, I'm hidden. Like I'm not your known expert. I'm not going to be discoverable. Like we're doing things in the dark to try to kind of get you settled or take a big picture. Because again, in this situation, like if you were like, we seem to be doing a lot of work and I don't know if it's going to, like, probably somebody had a spidey sense of like, we're doing too much over here. Call in a second opinion. Even lawyers, like if you're concerned about your lawyer, just like you said, like call in a nuanced lawyer. A lot of times we might even call in a business attorney if there are some nuances with the business, titling, transferring, separate things like that. Don't just rely upon, and don't allow your experts to gatekeep as well. So, I mean, I think that, at all times you have to kind of consider getting a second opinion or, some other information. So I think this is great. I think, we've adequately covered this case, and we'll look forward to more cases from you. Now, tell us a little bit. People can find you at bettingthehouse.com, but also you have a podcast, wealthlitigated.com. And, tell us a little bit more about how people can find you, the type of projects that you're working on, and what kind of thrills you.
Well, wealthlitigated.com started out as a podcast to help deep dive on one case to show you what went wrong with mistakes someone else lived, so you can simply learn from them and not have those same financial mistakes. And wealth defined broadly, we cover real property, but we also cover business assets, and we cover divorce and trusts and estates, and anywhere an asset of wealth is litigated, we cover it in a detailed fashion with this soap opera fact. So I choose these cases because there is significant information and key takeaways, but also just factually crazy, interesting, unique, and you can't make this up because it really happened. So that's the criteria, and that's at wealthlitigated.com.
Yeah, I love that. Well, we appreciate you always curating amazing cases, and we look forward to the next cases that we go through, because they're always interesting. And, again, cases that probably shouldn't have made it through the system, but we're happy that they do, because I would much rather learn my lessons through these case summaries as opposed to actual lessons in court, because those are no fun. I enjoyed some of those when I was younger, but I prefer not to learn them the hard way at this point. So thank you, Kelly. And maybe we'll see you next month.
Thank you, Melissa.